You think you can just walk out, hell, I'll quit, and still claim your full and your final paycheck? Think again.
It's Chaile time. Hello and welcome to this week's episode of Chaile Time. Toby, it's been a minute. Do you still remember?
I'm still trying to get used to that word. It's a minute. It's been a long while.
It's been a long
You and I've been doing Chaile on our own for the last couple of weeks.
How are you, Toby?
How
you've been?
I've been. Look, I think it's always going well with me. Just as always, challenges, busy, the business growing, and we have another HR consultant starting here on Monday. So the Effectus team is growing near Kanama.
Yeah, no, it's growing. And I was having a conversation with a friend the other day, I'm enjoying my job.
But I actually feel so sorry for you. I'm so happy to hear you enjoy it because, every single day, you're all over the country.
You don't have to.
One CCMA case after the next one, eh?
But it comes with me, interacting with a lot of people, learning a lot of things. The way I'm so now known at the CCMA in Johannesburg, there's this commissioner, it's a Zulu lady. She's Zulu, like Zulu.
Real Zulu.
Like Zulu. Yesterday,
like Shaka's wife, Zulu.
Yes. Yesterday I bumped into her about 4, 5, 6 times on the corridors there.
Yeah.
And she calls me and says, Mfana, hey, come here. Why don't you settle this case and leave this premises? I'm like, Commissioner, I've settled with you before. I'm a very reasonable person. I always humble myself when I talk to Commissioner. I'm a very reasonable person. But I'm dealing here with an 88-year-old woman who doesn't want to understand. She's like, she walked away from me. Because I think she knows, because I saw her with the commissioner who's dealing with our case earlier. I think the commissioner just told her that this is going on and on and on and on. But anyway, like I say, I'm really enjoying what I'm doing. And then the growth is amazing.
Yeah, it's nice. Look, being in this field, you get to deal with employers, employees, CEOs, the trade union, officials, lawyers, consultants, HR managers. Yeah, it's nice. It's a nice perk. It's nice to learn from everybody.
I compare our job like bartenders.
Yeah.
I'll come to that. I also compare it with like Uber drivers or taxi drivers.
Yeah.
Why I'm saying this? Every day in your life, you meet different people from different worlds. But in this aspect now, we deal with also, even taxi drivers, they deal with emotions. Sometimes you get in a car, someone is crying and then you don't know what to do. You look them in the mirror, you are an Uber driver. Sometimes you want to interact. Sometimes you keep quiet and just before they get off, they want to vent now. You don't know whether to stop your car next to the road, listen to this person or what. That's exactly what we're doing because like I always say to commissioners, Commissioner, I always bring that head of mine that say resolve. It doesn't matter what the employer said to me. I'm here to resolve,
Yes.
Because I'm looking at this person. They still have a future. They still have, that's just me now pulling that, Even though I'm here to fight, but, just to test the waters. Hence, I love this thing. And I saw now, they set down notice. They will always say, the commissioner will always say, it's always wise to object to con up to take place.
Because then you can talk.
Because then you can talk. And then first session, it's emotions.
But you had a nice commissioner. I wish my commissioner was so nice.
No, but I have a way of talking to people.
I had a commissioner 3 weeks ago. I wanted to settle on basically 1 month's salary. It's like it was maybe just a little bit less than 1 month's salary. It was 5,000 rand. Okay. This employee went through a 6-month performance review process. He even went to another department out of his own request to help him. The hearing eventually was 120 pages against this employee. In my professional opinion, he doesn't have prospects, okay? He was represented by a union official in the or at the CCMA. It was objected against, unfair dismissal disputes, was only conciliation. I tried to settle. Now, as you say, we actually do care about people's futures. Now, the thing is this: if you are being dismissed, let's say for coming late, as an example, you go through arbitration and you lose the case, then you have an arbitration award of late coming on your record. Okay, great. But this case now was poor performance. How will an arbitration look on your record that say you're an incompetent person?
Who's going to take chances?
Who's going to ever employ you? So I then said, Mr. Commissioner, he is represented. Why can't we settle a neutral reference letter and 5,000 Rand settlement? I was fighting the commissioner. He was fighting me. He actually made it clear to me that you can't settle on 5,000 Rand, and this whole nonsense about neutral reference letters is just simply nonsense. So eventually I had to ask the commissioner, are you telling me both parties, even if they want to, they're not allowed under any circumstances to settle on 5,000 Rand? Then he said, no, I'm not saying that. But I'm like, but you are fighting. You are saying, they are keeping quiet. Maybe you must ask them, the official, what do you say about this? You're not asking them their opinion. We didn't settle, so he filled in the certificate. They walked out confident they're going to win arbitration now. And I'm like, how stupid can this now be? See, because the commissioner didn't help us to resolve this matter. And you know what? 1 week later, CCMA Cape Town, this employee filed 2 disputes. The one was for the Monday and the other one was for the Thursday. The Monday was a Section 73 dispute, outstanding pays, deductions that was made. And then there was the Thursday unfair dismissal dispute because he was actually dismissed too. I settled both disputes for 5,000 Rand.
Voila.
Same time.
You see.
So, the company agreed to pay the 5,000 Rand for the one dispute.
Yes.
For the Section 73 dispute. I didn't say to myself, but listen, there's this Thursday dispute coming. So I told the guy, listen, are we someone going to include the Thursday case? No, he said, that's a separate case. Well, in that case, you don't get this money either. And the reason why I said that is because the CCMA didn't have jurisdiction in terms of our discussion today here, because it was a deduction dispute. The company deducted for unauthorized use of the company vehicles, so the company deducted for pay, for petrol and things like that. You see, so. But so my commissions are not always as friendly as yours.
No, I don't think they are friendly, but I think, I think I'm good with studying people. It's not always an achievable move. Like I said to you earlier when we were having a chat, saying, Commissioner called me out when I was trying to play dumb and say, but I don't understand this. I couldn't prepare the commissioner. You're taking chances because you have a 7-11. So it's always a chess move, always. But let's not deviate because
let's get to the podcast.
Woman on Tech is going to fight with us. Woman on Tech, don't fight with us. What are we talking about today?
So, this is a contentious issue. It is walking out, wiping pay. The truth about sudden resignations. Walking out, wiping pay. The truth about sudden resignations. There's this illness in South Africa. It's
immediate effect.
Resignation with immediate effect. And it's causing a lot of frustration to employers.
It's causing?
A lot of frustration to employers. Here you have an employee, now he resigns and he just leaves. What about notice?
Yeah, what about an opportunity for you to replace them?
Yes, and to do a proper handover. Yeah. So now in terms of the basic conditions of Employment Act, this law here, notice periods. By law, when an employee, as an example, resigns, he or she must give notice. Now the notice is if you've worked up to 6 months, you must give 1 week notice. If you've worked between 6 months and 12 months, you must give 2 weeks notice. If you work more and longer than 12 months, you must give 30 days notice. But now a lot of employees, they get a nice job offer from another company, nice salary, nice benefits, but that company wants you to start immediately. So what the employee do is they resign and just
disappear,
Go.
gone. And they think the money will fall.
Well, obviously they have not worked for the money, so maybe let's say they've worked 3 weeks into a month.
Yes.
Now, obviously they must get their salary for that 3 weeks and then also the accrued annual leave. No?
Yes.
Come payday. So
173 rand in my account.
173 rand in your account. Actually, when was this? This is Tuesday now. Okay, two days ago. I was at the company. In their contract, they actually have a provision that say, if you fail to work notice, they will equally deduct from your last pay for the period that you failed to work notice. So this employee failed to work notice, and the payroll asked, so what now? So the owner was also standing there. So then he reminded us of this clause. So the payroll then deducted the money for the notice that didn't work, and it came to a minus 114 rand. That must be paid to the employee. So this employee, obviously, they're going to get a huge shock now when it comes to payday, you see. So, but that is the topic of today's discussion. So the idea of the podcast today, Tsepo,
Yes.
is to talk to employees and to let them know, in this labor market where you have the interest of employers on the one hand and the interest of employees on the other hand, okay? And these interests often, they are competing interests.
And there's a conflict.
There's often this conflict. So if you're going to resign and think, life is beautiful, I'm going to get my money, don't be surprised
If you get 173.
if you get a minus 114 rand payslip. Because yes, you get the laws. You may think the laws say in terms of Section 34 of the Basic Conditions of an Employment Act, but the employer cannot just simply arbitrarily make deductions, unless they've given you an opportunity to make representations, why not to deduct, or maybe you've signed some kind of agreement that they can deduct, or whatever the case may be. Okay, so you think you are fully protected by the law, but life, especially when it comes to litigation, especially when it comes to the interest of two parties, becomes messy.
I know what you're talking about. I was in Durban sometime.
Tell me about the Durban. You had a case stuck a few days ago in Durban CCMA.
Yes, I was in Durban CCMA, and then actually there were two cases. One was for constructive dismissal, and then that led to the person saying, you know what, I'm done. I'm handing in my resignation.
Resigned and left.
Effective immediately.
Okay.
And she left. And then come payday, 173 rand on the pay slip.
Yeah.
And then she went to the CCMA to say, but
Section 73 dispute.
yes,
Okay.
she's owed money. And then, like I always do, I will just ask for clarification. I'm like, Commissioner, I'm not getting too much into the merits of the case. I know we're trying to talk. But before I pick up my phone and talk to the boss,
Yeah.
I need to get clarification. So, my lady, I'm not cross-questioning you. What happened here? No, I went, and then this is what was deducted. I'm like, oh, there was a deduction. Yes, there was deduction. They say I didn't serve notice, and then it was deducted. So does it reflect on your payslip, ma'am? And she said, yes, it reflects on my payslip. Then I'm like, Commissioner, she just gave us the answer now that she didn't work notice period, and the deduction was there, and it's reflecting on her payslip. The commissioner's like, I see where you're going with this, Mr. Kanama. I see where you're going with this. My lady, let me just help you already now. The CCMA doesn't have jurisdiction when it comes to that. Then you have to take the matter to the labor court. So I did it so nicely. Like, I
Commission did the work for you. You didn't even have to throw the legal argument. It was done for you.
It was done for me. And but there was this 2 days or 3 days of sick leave, and then the commissioner said, we're not going to arbitrate today. If you want to go for arbitration for the 2 days of sick leave and everything, actually you can do that. And then as soon as the commissioner, because I could see the commissioner was in a hurry,
Okay.
there's a backlog. There's a backlog at the CCMA, especially
in Durban, yeah.
even when you go to the CCMA in Pretoria, you will wait there, and then you understand. So most of the time, especially when I'm in Durban, the Section 73, they don't get arbitrated immediately.
Okay.
Because some people won't have figures, they don't have
73 generally is a very difficult dispute to
Yes.
arbitrate from scratch,
Yes.
in my opinion,
Yes,
because
yes, yes.
the onus on the employee to prove money is not paid.
Yes.
But on the 7-Eleven, they just say employer owe me money.
Yes.
They don't give any breakdowns.
Breakdown
and most
of
of the
how
time,
much and then-
the employers can't really prepare.
Yes.
They don't really know what this is about. So you come there. The first meeting is always clarification.
Yes, 100%. So I don't know if she's going to go for the 2 days, but I realized that after the effect, I do have proof that that money was paid for the 2 days sick leave and everything.
So the sick leave is not the
It's
issue,
not an
but the
issue.
issue is the deduction
Yes,
for the failure
for
to
the
work
failure
notice.
to work notice pay. So yeah, I understand exactly what you're talking
Yeah.
about.
So here's the thing, and this is for employees. If you're going to resign on the immediate effect, I'm not necessarily here now advocating that it is correct of the employer to deduct your money. That's actually debatable. I know some employers have like a contractual provision that say that if you're not going to work notice, they're going to deduct the money and you pay. I actually had a commissioner in Benoni CCM a couple of months ago, where there was also this kind of question about the validity of this contractual provision. And that we didn't go into arbitration, so it was only conciliation. I think the matter was settled, but we had a bit of a legal debate, me and the commissioner, and he was of the school of thought that, now he didn't make a ruling on arbitration, so I didn't ultimately know how he would have ruled, but he had a school of thought that when it comes to an agreement in a contract, that you must take it with a pinch of salt as the arbitrator now. And the reason why I say so is because, a collective agreement, for instance, okay, two parties will sit around the table and they will really negotiate the terms of that collective agreement. But when it comes to a contract of employment, it is very one-sided still.
Yeah.
Because the employee wants the job, they will just sign. There's no real negotiation. There's no real agreement. Okay, so that obviously opens a huge can of worms, and the lawyers here now is going to say, oh, yeah, so just hang in there, okay? We were just in conciliation talking. But be that as it may, okay, so the basic conditions of Employment Act, this is where it deals with deductions and sick leave and annual leave pays and all these kind of things, Section 77 says the following, just subsection 1, the jurisdiction of the Labour Court, okay? Subject to the Constitution and the jurisdiction of the Labour Appeal Court, and except where this Act provides otherwise, the Labour Court has exclusive jurisdiction in respect of all matters in terms of this Act. So this basically means, if you have a dispute with your employer in terms of anything here, unless this Act, that clause that you have a problem with, specifically allows you to go to the CCMA, you can only go to the Labour Court. Now the problem an employee has, or parties have, with going to the Labour Court is that it takes a long time.
Yeah.
Sometimes it can take up to 3 years. And it costs a lot of money because now you need to get yourself a fancy lawyer and advocate, and it takes a long time. But now employers know this, and they know that most employees are out of pocket. You see, so they start playing the elements. So what they do is on the payslip they will show. I'm not saying this is right or wrong. I'm telling you the do's and don'ts of what we see in the workplace. They will, on a payslip, show that they've paid you everything. They've paid you your notice, your leave, and everything. But that's on the left column, the income column of your payslip. On the right column, the deduction column, okay, they will deduct your medical aid, for instance, your provident fund, your UIF, your COIDA, and all those kind of things, which is right. Nah? But they will then also make a deduction for failure to work notice, and then they will take your last month's salary or your leave or whatever the case may be. Now it reflects as a deduction, but here's now the problem here. Deductions are specifically regulated by Section 34 of the Basic Conditions, and that specific section doesn't say the CCMA has got jurisdiction to deal with deductions. Now, the only section in terms of the Basic Conditions that an employee can file a dispute if you're earning below the earnings threshold is Section 73A. But here it becomes complicated, it becomes technical, Chaile. Because Section 73A say claims for failure to pay any amount. So if an employer doesn't pay you something, that money that's owed you, you can now go to the CCMA in terms of this section. So this is one of those exclusions. And it actually specifically say, despite Section 77, the one that speaks about the exclusive jurisdiction for the Labour Court, an employee or worker as defined in Section 1 of the National Minimum Wage Act may refer a dispute to the CCMA concerning the failure to pay any amount owing to that employee or worker in terms of this Act, as an example. Now, this is where the interpretation of law can sometimes become very difficult because you feel as an employee they failed to pay me something. The employer feel they did pay you, but there was also a deduction. So the deduction part of this argument falls under Section 34. So what is this now? Because it feels on one level, it feels right that you owe me money, you failed to pay me. The employer is saying, but we didn't fail to pay you. Yes, your pay slip, there, the payment reflects. But we also deducted. Now, it actually becomes a deduction dispute in terms of Section 34. So sometimes it's very, sometimes people will read the law for many years to really understand it. And after 30 years, you have your aha moment. Yes. This is what it really means. And I think this is one of those elements. You don't have to take 30 years to understand it, but it is sometimes difficult to differentiate between the difference between not paying and the employer deducting. Another dotted line example maybe that illustrates this complexity is, for instance, an employee don't come to work. Let's say one day he didn't come to work, just one day, okay? It's not sick leave, it's not annual leave, it is just an unpaid day off, okay? Now the employer pay your salary, your full salary, except that minus that one day. Now, did the employer deduct? In your mind now, you deduct something from your pay. Or did they just pay you what you worked for?
They really paid you what you worked for.
You see, sometimes the law plays with your mind, eh?
That's what I'm saying. Sometimes there's the law and there's technicalities. But the law itself can be technical sometimes. Can be...
Yeah, you see. So, but now it seems like how the CCMA, this matter of Section 73A, so now you just resign, leave, the company don't pay your leave out, your annual leave, or they deduct for notice you didn't work, okay? I'm personally not convinced that it is entirely fair and correct to do that. In terms of Section 34, that is. You can't just deduct pay from people's money. So if you do go to the Labour Court, you will probably end up winning the case. But it's going to cost you 200,000 rand to get there. You see what I'm saying? So I'm not saying what the employers are doing here is substantively correct. But I can't say that's not necessarily so, because sometimes there are real legal arguments attached to this dispute. So I can't sit here and say it's always wrong either. That's the whole point. It must be litigated. Okay? But if you're going to go to sections to the CCMA in terms of Section 73A, the question then is, does this become a failure to pay or a deduction issue? And I've seen now with the CCMA, when this kind of dispute, even with your situation now, yes, commissioners are starting to agree they don't have jurisdiction to deal with it if it is a deduction.
But now, my question will be, so if the deduction is done, but it does not reflect on the payslip, it's not broken down. You remember we had an issue about 2 years ago, 2 years ago, when the commissioner was like, it's better to deal with me rather than deal with you. When we had people who didn't understand their pay structure, because everything is consolidated and just say basic salary and this, but it doesn't say hours worked, Sunday time, but everything was included there, but there was no breakdown. You remember?
I remember.
And people were confused. And then later, after a lot of arguments, actually people were overpaid.
They were substantially overpaid, I remember. Yeah.
You remember. Yeah, but now we're looking at the fact that the deduction is there, but it's not reflected on the payslip. It's not broken down so that the employee can. So now how do we deal with that?
Well, you see, this now becomes a matter of litigation. And sometimes your evidence are clean, sometimes it is not. Just the fact that there's no breakdown on the payslip does not mean the employer will necessarily lose their case. At the end of the day, parties to litigation, the idea is to convince the judge or the arbitrator or so. And the way to do so is through solid evidence. And if you don't have that evidence, it becomes uncertain, it becomes messy. Not impossible, though. Look, in the example, the underlying facts is what it is, even though it wasn't reflected on the payslip properly. So if there's a deduction, let's say as an example now, If it is, can be demonstrated that it is because of an employee didn't work notice, so then yes, then I suppose it can be common cause that there was a deduction made, even though you don't have the payslip to prove that. Whether that's fair or not, that is, a subject for litigation itself. But at the end of the day, just some pointers here. The basic conditions basically does state that you need to provide an employee with a breakdown of the pay.
Yeah.
So if you didn't do that, then the employer, first of all, are in breach of this act in any way.
Yeah.
So it becomes more difficult for the employer. You may lose the confidence of a judge, for instance, who then says, listen, employer, your house is clearly not in order. He doesn't believe a word that comes out of your mouth. It may end up like that way. It's messy. So a messy case is never a good case. But it's not to say that you will necessarily lose a case just because it's messy. Like in your example, you were quite clever in asking the employee to explain, because now the employee admitted to the deduction. 100%. So even if you had a payslip or not, she already admitted to it, you see. So you have to see where litigation takes you.
Yeah, no, I do understand. But now also it shows employers that also when you apply that method, you also need to give a breakdown, because it might be messy at the end of the day.
Yeah, keep it clean, show, the incomes and the deductions in terms of pay slips. But having said that, doesn't necessarily make it fair to just simply deduct money.
Yeah, I think actually this gave me an idea, but I think we'll address it some other time. But let me just...
I'm not supposed to give you ideas now.
No.
Are you going to tell employers not to fix their pay slips?
No. Oh. I'm saying this whole episode for today has given me another idea of something that we can talk about.
Except for last week's Charlottetown, the people commented there that apparently I'm unethical. I'm not telling employers what they must do. I'm saying this is what's happening.
You're sneaking in corridors. You're sneaking in corridors.
Sneaking around the corridors. It was an accident.
No. I'm just saying that this now can just take us moving to deductions for damages, but it can be an issue for another day.
I think the next podcast will do that. I want you to think of episode 2 to follow on. Yes. What is the correct way of how to deal with deductions?
For damages.
And what does the law say?
Let's say you dismiss someone for malicious damage of property or whatever, of which it's a huge damage, and still opt to deduct. So we can deal with that in the next episode.
Let's deal with that with the next episode. Yeah. Let's continue the conversation.
Yeah, but I just wanted to give you a hint.
I think I also thought, let's just do a proper podcast on deductions itself. Section 34, let's deal with that in the next one. Yeah.
We got excited of seeing each other today. We didn't talk about the news. Because we haven't seen each other for such a long time, we are so excited, and we're doing a catch-up. We didn't talk about the news.
Zeppo, there's so much happening in the news now.
What is the government saying about...
Just the Department of Employment and Labour, they are upping their effectiveness. Yesterday I saw the one budget from the Treasury, something like 3.7 billion rand a year to employ an extra 10,000 labour inspectors. Also, they're saying they're going to increase penalties now for people employing illegal immigrants, now also start laying criminal charges. So somebody at home at the Department of Labour worked up.
Yeah. So that actually gave me an idea of saying, we really actually don't have a serious unemployment problem in South Africa.
Why?
The problem is undocumented people are getting employed at a cheaper rate.
Yeah.
Because some employers doesn't want to pay the minimum wage, they don't want to comply with your quotas and then all the laws and the rules, but they choose cheap labor to employ undocumented people. So whereby if those jobs were allocated to South Africans who are unemployed and be paid at the correct minimum wage.
They know this book.
You understand?
South Africans know.
But now they're going to get caught out, they're going to go to jail, and then it's becoming messy.
I'm already seeing that.
It is.
Some of our clients also, immigration will just pitch up and start finding people and staff running away. It happens.
Okay.
Anyway, so
job reviews.
Job review. Let's just look at all the fresh vacancies in our networks this week. See you next time. Bye-bye.
Bye.
Good morning, Harmony people. Let's have a look at some of the vacancies posted nationwide on our Harmony People's Network this week. First up, Ismail and Daya Attorneys is seeking a sales manager in Boxburg. Cytec is looking to hire a warehouse operations manager, as well as an AI and process automation assistant in Durban. And last but not least, there is an actuarial data analyst position based in Joburg. For the full information of the mentioned positions, how to apply, as well as more available positions, find the vacancy link in the description. You will also find a link to a useful video on how to compose a winning CV and have a successful interview. Tune in again next week for more Harmony vacancies.